Show you something real quick. This is called the 12 Presumptions of Court. So I made this document that orders and commands them to take mandatory judicial notice according to the rules of evidence of the following testimony before God that the undersigned rebuts. So there's 12 presumptions asserted by private bar guilds, which if unchallenged stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, executor de suntort, incompetence, and guilt. The presumption of the public record is that any matter brought before a state court is a matter for public record when in fact is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains a private bar guild matter completely under private bar guild rules. The presumption of public service is that all the members of the private bar guild would have all sworn a solemn secret oath to their guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oath to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. But they're not. The presumption to public oath is that all members of the private bar guild acting in the capacity of public officials have sworn a solemn public oath, remain bound by the oath, and therefore bound to serve honestly, impartially, and fairly as dictated by their oath, unless openly challenged and demanded. The presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest that cannot possibly stand under a public oath. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability unless openly challenged and their oath demanded. The presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from any personal accountability for their actions. Number 5, the presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept the position, defendant, juror, witness, and jurisdiction of the court. Attendance in court is usually by invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and the existence of guilt stands. Oh, I'm sorry, I read that wrong. It says, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt stands. I do this in every court. I rebut the presumptions with mandatory judicial notice, and I make them jump through all these hoops before we even get to talking about the case. The presumption of custody is that by custom, a summons or warrant or arrest unrebutted stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul possessing beings, unless the presumption is openly challenged by rejection of summons and or at court. The presumption stands that you are a thing and property, and therefore lawfully able to be kept in custody by custodians. See, idiots like Van Balian and this who's this other guy that we were just watching? I forget his name. He's an idiot. But they don't understand stuff like this. So they say a bunch of dumb stuff on their channel about sovereign citizenry. The presumption, number 7, the presumption of court of guardians is the presumption that you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P. You are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians, unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, trust before the court. The presumption stands and you are by default a pauper and lunatic, and therefore must obey the rules of the clerk of guardians, clerk of magistrate court. The presumption of court of trustees is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter and you are not a government employee or public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared. Number 9, the presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoints the judge, magistrate in capacity of executor. while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. If the accused does not seek their or assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an executor de suntore, or false executor, challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation, unless his presumption is openly challenged to demonstrate you are both the general guardian and general executor of the matter, trust before the court, questioning and challenging whether the judge or magistrate is seeking to act as executor suntore. The presumption stands that you are by default the trustee. Therefore must obey the rules of the executor, judge, magistrate, or you are an executor de suntore, and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert their false claim against you. What I can say is none of this stuff has ever happened to me. They never arrested me. They never charged me with contempt. They never charged me with practicing law without a license, like this dickweed team skeptic, this idiot that keeps talking about this license that doesn't exist and how you're going to get a felony for practicing law when the license doesn't even exist. This dude is an idiot. He doesn't know anything. Number 11, the presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to represent yourself and argue properly. Therefore, the judge magistrate as executor has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation, unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary, and actively rebuke and object to any contrary presumptions. Then it stands by the time of the pleading that you are incompetent, then the judge or magistrate can do what they need to keep you obedient. The presumption of guilt is the presumption that is presumed to be a private business meeting of the bar guild. You are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you have either previously arranged an affidavit of truth, a motion to dismiss with extreme prejudice under the public record, or call it the murmur, then the presumption is that you are guilty, and the private bar guild can hold you until the bond is prepared to guarantee the amount the guild wants to profit from you. That's 12. So, I do formally challenge the presumption of guilt. So, equity does not aid a volunteer, and Scripture is clear that he is not to stand as surety for strangers. Proverbs 6, chapter 6, verse 1 through 2, and verse 11 and 15. Romans, chapter 13, verse 8, 2 Kings, chapter 18, verse 23 and 31 of the King James Bible. And then I just write my first name, Marcus Natural Subject without recourse, all rights reserved, void ab initio. I dispute this debt and all claims in accordance with 15 U.S.C. 1692G, void ab initio. And there's the code. Person acting representative, sons and instrument by something. I'm not going to go off of this. This is a little less important, but this pertains to when you send the citations back to them and don't accept their citations. You have the right to rescind your signature. That's what that's about. So here's one. Let's see if Van Balian or Team Skeptic picked this one up. I noticed they didn't pick this one up. They didn't pick up the other one. The what is it? Breaking the public side, number 1 and 2, with my talk with the attorney, where he says that there's a public and private. They won't touch any of those videos because those videos would make them look like a bunch of idiots. So have a good day, everybody.